Famous.
Hello, everyone. My name is Diane Donnelly, and I am with the Donnelly Group of Keller Williams Flagship of Maryland. And today we're going to be talking with Chris Breck. Chris Breck is one of my go-to guys with Charter Title, and he is going to be talking today about holding title and some pitfalls and things you should consider when you're deciding whose name to put on paperwork. And our series here was born from COVID, and so many of my clients, friends, and family asking questions about what's going on with the economy, what's happening with real estate, what should we consider, what do we need to be paying attention to, and just so much misinformation out there that we thought we would pull together this series called Facts Not Fears, so that you can make decisions based on facts and not on emotions. So Chris Breck, please tell us a little bit about yourself and a little bit about Charter Title.
Thanks, Diane. Chris Breck, one of the partners at Charter Title. I've been doing this about 15 years. I had the pleasure of working with you. I can't even remember how long now.
Well, more than 15, because when you were with Advantage Title, we did business then too.
Yeah. We built our business just on helping people and being there to answer questions and doing things the right way. And things have been going good, and we're very, very blessed and very happy to work with some amazing agents and be a part of a beautiful, beautiful process when people buy a home. And it's a great thing to be a part of, and a great part of a person's life. And I love being able to help them.
Well, you guys, I could brag about you all day long. I just think Chartered Title just does an amazing job in pulling everything together, keeping things calm when things can get a little antsy, being the source for, how should we hold title? Or Chris, what about this? I see this on the deed. What should we be concerned about? How should we put the paperwork together when there is an estate sale? Things of that nature. But there's so many questions that you guys are a resource for, and we always appreciate that.
Well, thank you. The devil's in the details, right? Isn't that what they say?
Oh my gosh, devil's in the details for sure. Now let's go ahead and get started on the topic. Today's topic, how to hold title. So let's back up for a second, and people that aren't in the industry might not know what that means. And I do want to apologize in advance. I have a little scratchy throat because of allergies, not because of COVID. So I'm going to take a couple of sips of water as we go through here. But Chris, what does holding title mean specifically?
Holding title is I guess you call it the tenancy that is involved with multiple names being on a property, and what happens in the event that somebody on title or that owns the property passes, what happens in the event that somebody gets divorced, what happens in the event that somebody wants to sell. There's different ways to hold title that can determine from a legal aspect what happens next.
And I want to tell you, I think this is a really, really important topic, and one that is not discussed very often. I don't know if ever people say to Andrea, who works with buyers on our team, how should I hold title? Or what are your thoughts on holding title? I know you guys probably get more of those questions, or maybe not, but something certainly that people should be aware of, that there are different ways for people to hold title or hold tenancy, and how the when the situation dissolves itself, for those examples that you gave, a death, divorce, things of that nature, what should you guys be thinking about, or people be thinking about in advance of that? I do want to share an example quickly, Chris, with you. So I was, which was the genesis of this topic, was I was getting my nails done, and the lady said, my son is getting ready to buy a house. I want you to help him. I said, fantastic, would love to help. And she said, he's buying with a friend. And I said, okay. And anytime somebody says that, I just think, okay, there could be some things that they need to think through. And I said, if you don't mind my asking, how are they going to hold title? How are they going to put the names together? And she said, I don't even know what that means. And I explained it a little bit to her. And I said, when there's friendships, everything is great until something isn't great. So you need to think of things that if down the road, God forbid, there's a parting of ways, people have go in different directions, whatever the case may be. How you hold title, especially in a situation like that, is very important. So nobody goes into a real estate transaction thinking there's going to be a divorce, or there is going to be us parting ways. So something that is so important, so critical for the largest asset should be, considered, and conversations should be had about it. So I said to her, well, in the event that something happened and these two parted ways, how would you want that to be resolved? And she didn't understand. So I said, I'm going to connect you with my friend Chris, because he's going to be able to explain all of this way better than I can. I can give you things to think about, but I don't know the details and the answers for the behind the scenes stuff the way that you do. So in this situation, it's a young man. I'm going to guess he's probably early 20s, and he's going to go buy a home with a gentleman who's probably very seasoned, good family friend, maybe 50s or 60s. What would you advise, or when you give counsel, what do you talk to them about? And if you want to go answer that at the end after we answer some of the other questions, Chris, we can do it that way too.
Well, I think we can dive into this one. So there's 4 ways to hold title. There's sole owner, which I think is self-explanatory, and that doesn't apply here. Then the other one we're going to roll out is, and we can talk about this one later, is tenants by the entirety. That is for married couples, and that has some things associated with that. We'll talk about that in a little bit. So in this situation, they're deciding between tenants in common and joint tenants. Joint tenants is it's presumed 50-50 ownership, and it's presumed that if something happens to one party, ownership automatically passes to the other party. We call that right of survivorship. Now, tenants in common is the other option. This is what we see a lot of, sometimes investment properties or unmarried couples. You can do that 90-10, 80-20, 50-50, whatever you want. And then you decide what happens with your ownership. So if the 10% owner wants to, sell to the 90% owner, they can. It's just a matter, it's really thinking about what happens in this case. What would happen if somebody were to pass? What would you want to happen with the property?
I've dealt with sole ownership, I've dealt with tenants by entirety, and I don't know if I've dealt with the other two. Who writes up that paperwork? Does a title company, or does an attorney draft it and give it to a title company?
It's going to be in your deed. It's going to,
okay.
So an attorney will prepare the deed. And the way we do it is we ask in the beginning of the process, and we basically have a checklist that describes each type of tenancy, and lets them
okay
pick. And if your viewers want to see that, I'm happy to share that. I'll throw my email in the comments and send that out.
Oh, great. Yeah, well, I would appreciate that. So if people have questions about tenancy, please email Chris. We'll have that information at the end. So the 4 ways to hold title. Let's break it out now one by one. The first one is sole ownership, which is pretty clear. If you're buying alone, you buy sole, right?
Correct.
Nothing complicated there, Chris, right?
Pretty simple,
okay.
Yeah.
Okay, the next one is tenants. Pardon?
So yeah, tenants in common. I feel like we kind of dove into that one a little bit. That's the one that's, it can be 90-10, 50-50, whatever you want to set it up. We see this a lot in, I guess you could say, business relationships.
Mm-hmm. Yep, 50-50, okay. And then tenants by entirety, you must be married, and you hold title 50-50. And I mean, you hold tenants by entirety. Is that assumed a 50-50 as well?
It is, and actually, if you're married, it's assumed that you want tenants by entirety. If you don't state otherwise, you're going to get tenants by entirety.
What about domestic partnerships? Can they do a tenants by entirety?
Now they can, yeah.
Okay.
Luckily, they progress, and we can. If you're married, you can be tenants by entirety.
Okay. No different rules. Okay, then we go to tenants in common, 50-50 split.
No, tenants in common is the first one. It's the however you want. The joint tenants.
Oh, that's the breakdown. So with tenants in common, my question was, that can have as many people as you need to or want to on that one?
Mm-hmm.
Okay. And the last one was tenants.
You get as many people on all of these. It's just all the other ones, it's assumed the ownership is equal, other than tenants.
Okay, it's equal, not 50-50, but it's equal.
Yeah.
Okay, that's what I was missing. Here's another question. If a married person wants to buy a loan and hold title as sole owner, right? So they're buying it, they're married, but they're buying the house on their own. Does the spouse have to sign something that says, here's a quitclaim deed, for example, you can do this?
Yeah, if you're married, the spouse still has to sign off, allowing you to, because I forget what the word is for it, but in the state it's the couple is presumed as one entity, so they own things together. So even if you're not on the loan, you still have to sign allowing for a loan to be on property.
Yeah, now that makes sense. I had a situation one time where there was a married couple. The husband took loans out against several secured loans out against the house without the wife's signature.
Yeah, nope.
How did that happen, right?
Yeah, it wouldn't hold up, unfortunately.
Yeah, but that was a bad situation, but it's done. Okay, so you can do that. If you buy a home as tenants in common and you don't have a will, your share of the property will be distributed based on state probate law. Is that true?
Yes, it is.
Okay. So if you buy tenants in common and it's all, okay, I keep forgetting which one's which. Tenants in common is the one with 50-50 or equally split, or is that the one that you can decide
Tenants in
whichever?
common is the one you decide what you want. What we see, most unmarried couples will do joint tenants, just so that if something does happen to one, the ownership does pass. But people also need to think about it. What type of, it's all about what you want to happen to the property when you pass. So let's say it's your second marriage, right? And you have you're putting your new spouse on the beach house or something that's been in your family for generations. If you want that your ownership to transfer to your children and not automatically to the new spouse, this is when you would set it up in tenants in common, so you can control what happens with your ownership. If it's joint tenants,
I think that is such an important concept that people, when buying homes, miss. Things of that nature, because that's not different than doing an astute due diligence with estate planning. It's to say, okay, if I have to do something with this property or I pass away, this is natural to think I need to figure out what to do with my property. And a lot of times if it's a healthy, wonderful marriage and everything is perfect, that's great. But sometimes things change after marriage and relationships change, so that it should be thought through. No different than an estate plan. Would you agree with that, Chris?
Oh, I would. I would never discourage anyone from buying a house. It's the financial cornerstone. It's a cornerstone to your financial freedom. It's the best way to build equity and grow financially. But we do see relationships fall apart, and then somebody is usually stuck in a messy situation. When you buy a property, let's just say, for the sake of example, in Arundel County, $300,000 property. If you and your couple, like let's say not married, if a couple buys a house, you're going to pay, you're going to split the recordation costs with the seller. So it's going to cost you about $2,500 in recordation tax to record a deed, right? If something happens and you end up like splitting up and one party has to buy the other party out, well, there's no breaks on that. And if you get divorced, there's a break. You get a break in the recordation costs. If you're just like dating and you separate, there's no breaks, and it costs like $6,000 in recordation costs to get that transferred. So it's something people need to think about.
Yeah, that's interesting.
Yeah, and unfortunately, same people will they'll go on a loan together, and one person, they'll break up and they say, well, I'm off the loan now. Well, no, you're not. Unfortunately, you're on that loan forever until it's paid off. That's not how it works.
I had a seller situation just recently where it's a divorce situation. The divorce decree states that they have to sell the home and the assets go to the wife. He will not sign the listing paperwork.
No.
To sell the home. And I thought, but it's in the divorce decree. It has to be done. He's still not signing. It doesn't matter. He said, it doesn't matter. I don't care what it says. I'm not selling the home right now. Isn't that interesting? So now it's a big battle.
Yeah. A judge will, make it happen, but that's just more hoops to jump through.
More and more money for the attorneys to have to duke it out. And they thought they had this all planned out, but it happens. What about when a living trust is in the situation? So if a living trust, do you advise doing the living trusts in holding title?
Absolutely. I think that's a great way for estate planning. I think we could do an entire separate video on that, and I could bring in some other people as well. It's not,
love that.
We don't see it a lot. But it's something that people need to think about because for estate planning purposes, it can be very good. However, the way you set it up can also stop you from getting a loan on a property. So you have to set it up in the right way as well. But that, like I
Right,
said, that's a whole other episode.
yeah, and yeah, that's a good topic. And I know that sometimes with trusts, some mortgage companies will not allow that.
Right. It
And
depends how
some will and some won't allow it.
Yeah, it depends how it's written out. Typically, we have to provide a copy to our underwriter and to the lender's underwriter to make sure everybody is okay with it.
On board. Okay. Okay. Kayla, does anybody have any other questions? And then I want to do a quick recap of what each of these is.
You don't have any questions at this time?
Okay. Thanks, Kayla. So Chris, as a recap, we can, people who are watching this, if you're buying a home, you can buy sole ownership, you're buying by yourself. That's the way to go. The
Yep.
second one is if you're married, you're going to be assumed to be tenants by entirety.
Correct.
And if something happens to you, it passes on to, what's the difference then between tenants by entirety because you're married and joint tenancy that you're not married, but it's still a 50-50 assumption?
Great question.
Thank you, Chris.
The number one benefit of tenants by entirety is protection from judgments. So
Tell me about that.
If there's a judgment against one party, they can't put a lien on the house because it's assumed that you're one person, and the other person had nothing to do with it, so you can't put it against your property, except for federal tax liens. Those trump everything. Pay your taxes, people.
Pay your taxes. Don't let that snowball.
Don't let that snowball. With joint tenants, someone can put a judgment against one party, and it just goes on their share of the interest. Tenants in common as well.
Okay.
But tenants by entirety protects you from judgments.
Okay, that's good to know. Okay. And then it was interesting when you said that about the divorce, you're protected from recordation on that. I didn't know that.
Most counties will give you a break. Yeah, I think I'd have to check them all. Every county gets to make up their own rules in Maryland. It's one of the unique things about us.
Okay.
But yeah, family members, mother to son, father to daughter, those are generally tax-free. But once you go outside of that, or divorces are tax-free. Once you go outside of that's when they start collecting recordation taxes.
Okay. Okay. And then we've got the tenants the tenants in common, which you can say how you want it split, whatever the percentages are. And
Correct.
then.
And there's no right of survivorship with that. Then you decide with your estate what happens with your ownership. It doesn't automatically transfer to the other parties.
Okay. And then joint, it does transfer. So I think my hope is that at the conclusion of this, when people see this, it just says, something to consider. I need to talk to my title guys about how to hold title. And for my unique situation, what should I be considering? And then make good, solid decisions based on the information that we got today.
Yeah. And, I hate to be like that, but, take the worst case scenario and have that discussion with your partner. What's going to, if something goes wrong, how do we want to handle this? It's a tough conversation because you want to believe everything's going to work out, but it's a big decision, and you gotta make the right choice.
And we all know that we are going to pass. Each of us knows that that's going to happen. So another conversation that we don't want to have but need to have is, in the event that this does happen, what do we want for our future? So really valuable points, Chris. I really appreciate it, and thank you for coming on to talk to us today.
Thank you for having me. I love being on the Diane Donnelly show.
The Diane Donnelly show. I love that. I should get some remember Sally Jesse Raphael? Remember her with the big red glasses?
Yes.
I have to get some signature glasses.
I think you should go for it. Yeah.
I'm going to try it. I'm going to do it. And then Kayla, do you have information for Chris and how to reach Chris if anybody needs to reach him?
Yes, I'm putting it up right now.
Fantastic. And then Chris, the last thing that we have to do is circle back to the situation that we talked about in the beginning, this young man and his friend, the family friend. What are your thoughts?
My gut says tenants in common.
Mm-hmm. That's what I was thinking after the education today.
Yep, and especially if one party's putting some money down, if sometimes people aren't putting the same amount to buy the house, you can break that up. That way you can decide what happens. At one point, you can buy the other side out, or transfer. It depends on what if it's a friend or a business relationship, to me, I say tenants in common. If it's a couple, then you start thinking about joint tenancy.
Got it. Chris, you're the greatest. I appreciate you. I appreciate Charter Title, all that you do. If you are in the area and you are looking to buy or sell a home, Charter Title is the closing company of choice. Here is their information, and you can reach Chris if you have any questions about this or any other topic pertaining to closing a home. So we thank you for listening. If it's helpful to you, please share this on your page or send it to somebody who is looking to make a purchase, and we would be happy to help them. And until next time, we'll see you soon.